Welcome to the Rural Press Club of Victoria's online seminar on court reporting. My name is Greg Dundas and I'm a committee member for the Rural Press Club of Victoria. I'm a working journalist with a longish history of working in newspapers here in Victoria. We have three very knowledgeable and highly qualified panellists here tonight. Joining us in the centre of your screen is Sally Flynn, criminal lawyer and prosecutor. Sally signed the bar roll in 2004 and was appointed a silk in 2017. She's a highly experienced trial advocate and has appeared at all levels of the criminal law jurisdiction, including appearing in a number of murder trials in the Supreme Court. Sally appears for both the prosecution and the defence and is vice chair of the Bar Association. On the right of your screen is Tammy Mills. Tammy Mills is a journalist at The Age. Tammy got her start in journalism at the Shepparton News and the Border Mail, where she covered, as most regional reporters do, everything, but she specialised in crime with a healthy dose of court reporting. She's been with The Age for almost a decade, covering crime, courts, legal affairs, and has now moved into the burgeoning podcasting world. And our third and final guest is Justice Richard Niall SC, a Victorian Court of Appeal judge. Justice Niall was appointed to the Victorian Court of Appeal in November 2017, where he sits in both criminal and civil appeals. In June 2015, Justice Niall was appointed the Solicitor General for Victoria. He was admitted to practice in 1991, signed the bar roll in 1995, and was appointed Senior Counsel in 2010. That's our introductions over, and it's time now to move on to some questions. Your Honour, I'll start with you, and I think the best place for us to start on a chat like tonight is to perhaps get you, with the other panellists, to explain to us how a criminal matter proceeds through the court system, because it can be a complicated process and there are a number of rules that media need to be aware of along the way, aren't there?
Yes, thanks very much, Greg, and welcome everyone. I'm very pleased to be able to join the discussion tonight. I thought it might be useful to commence our discussion by just identifying the steps in the criminal justice process or system where the media become involved. And the first, and tonight we'll really be focusing on the criminal law, the first and most obvious incident is the crime itself. And that may be very public, or it may not be revealed for some time. And that will commence the criminal investigation by police. So that process of the crime itself, its immediate aftermath and the investigation are likely to be reported by criminal crime reporters, crime rounds people, and no doubt that process will be largely informed by what information the police provide and also the journalist's own investigations. And the police experience has shown are pretty experienced at knowing what can and can't be disclosed, what might or what might not assist the investigation, what might or might not assist in any ultimate criminal prosecution in the event the charges are laid. So we've got a crime, we've had the investigation, and then we've got a criminal charge. And that commences, and that's a critical point because it commences or engages the court process. And once we're in the court system, quite a number of different features and different aspects are important to take into account. And that starts with a charge. And if it's a serious crime, it'll then proceed to a committal. So a committal hearing is a hearing in the magistrate's court where a magistrate is charged with the responsibility of determining whether the prosecution have enough evidence to proceed to trial. At that point, the accused will be generally represented, but it's not a trial, it's not an occasion to hear all the evidence. The prosecution evidence is usually written statements, and one or more or some of the witnesses, proposed witnesses, will be allowed to be cross-examined. And that'll be an opportunity. It's in court, and we often see the news reporters seeing the accused with their lawyer coming into the Magistrates Court at Melbourne or leaving, and that'll be will be an occasion where there'll be some reporting about the charge, about the criminal process. Usually there's not a lot of information other than the allegations that the prosecution make. There might be a little bit of evidence that emerges in the committal, and we'll come to reporting of that evidence in due course. So assume that the accused, there is sufficient evidence, it then goes to a trial. And this is where the reporting becomes probably the most important, but it also becomes the most difficult, because that's where misreporting or publication of things that have been either suppressed or will not go before a jury can cause real problems. And that's where we tend to get issues. So the trial process, I think it's worthwhile just a little bit of time just sort of charting out the steps in a trial. A trial is as you all know, the hearing of the criminal charges before a jury of 12, and it's the prosecution's task to prove the offence beyond reasonable doubt on the basis of evidence which is admissible in the trial. And one of the judge's responsibility is to ensure that only evidence that's admissible, that is only evidence that complies with the rules of evidence, is put before the jury. And that means sometimes excluding evidence which might be very prejudicial, it might be very interesting, it might be very exciting, but for one reason or another, it can't be led before the jury, because if the jury were told it, that would threaten the fairness of the trial. An obvious example would be the possibility that the person accused has been convicted of other crimes, or has been in jail for other crimes, or has particular history. So the judge's role is to determine what evidence goes before a jury. And so before the jury come into the picture, there's usually pre-trial argument, and that will occur in open court, where the prosecution and the defence will argue about what evidence should go in and what evidence should go out. And in that process, there might be a lot of evidence, which, as I say, is highly prejudicial, very interesting, would make great news reporting, but ultimately, if it's ruled inadmissible, it can't be before the jury, and publication of that evidence or that material would really threaten the fairness of the trial and would cause significant problems. So they have this pre-trial argument. So that's in the absence of a jury. You haven't got the jury yet. And that's when the ground rules of the trial are really worked out, and that's when you've got to be especially careful in your reporting. Then there's the empanelment of the jury. That means the jury is struck randomly from a pool, and then once they get a jury of 12, sometimes they have reserve jurors if they think the trial's going to go longer. You have a jury of 12, and that's when the evidence is led. It's a pretty fair rule, and I think we'll come to it. Whatever the jury are told, there's no problem in fair reporting, fair and accurate reporting of whatever the jury is told, because you're just reporting that which the jury hears. The problems, if you start reporting things that happen when the jury are not there, there's a real risk that the jury might read material that the court has ruled or the parties have agreed should not be adduced. So then you have evidence run in the usual way, and there's plenty of opportunity for reporting, fair reporting of that evidence. And I'm sure Sally will say a bit more about reporting evidence and the risks of not waiting to hear how the evidence unfolds. And then at the close of evidence, there's closing addresses. The prosecution will go first, and they'll set out the way the Crown put their case, and that's a good opportunity to understand, again, the summary of the prosecution. So that'll really be how the Crown are seeking to persuade the jury that the accused is guilty. Then the defence will put their version of events, bearing in mind, of course, it's for the Crown to prove everything. And then finally, the judge will charge the jury. That is, the judge will direct the jury on the law and say something about the facts, and then there'll be a verdict. And then the verdict will then bring the trial to an end. Then after that, there'll be a sentence. If the person has been convicted, there'll be a plea. And that will often be some weeks, perhaps even months after the trial. So there'll be another opportunity for reporting. And again, it's a different environment. There's not so much risk of prejudice in the system about reporting what said, there's no jury involved, and then you'll have a sentence and then you'll have an appeal. And again, reporting after verdict, after sentence and before the appeal presents less problems because we've got jury we don't have the jury involved. So that's the system in a nutshell. And obviously your reporting might occur at the crime investigation stage, the charge stage, the committal stage, the trial stage, and the sentence. And one of the purposes of tonight is to try and explore amongst the three of us with some of the pitfalls and some of the tips in reporting, particularly the trial, and the dangers of coming in when the editor says go down and report the trial that's been going on for 3 weeks, and you hear something which looks particularly interesting and you write a report and you don't have the context, you don't really understand it, and it's very difficult to make a fair report if you don't know the bigger picture. So that's really the summary of where we're at. And perhaps we might start with you, Sally, perhaps identifying a few issues about reporting at the trial stage.
Thanks, Judge. Well, I think barristers generally come at it from a different perspective depending on whether they are prosecuting the matter or whether they are defending the matter, acting for a particular client. So as far as a prosecutor is concerned, I think the main wish of any barrister in the trial, but particularly the prosecutor, is that the process is fair, that a fair trial is run, and their job is to obviously assist the judge and make sure that happens. But in terms of reporting, I think from the prosecution side of things, concerned that there is accurate reporting, that if there is a particular complainant or victim in the matter, or a family of a deceased, for example, that they are protected as much as possible. Whereas the defence have a different perspective, and that is that they have a client going through perhaps the most stressful time of their life during a criminal trial. The last thing that they want to deal with is this matter being on the front page of the local newspaper or the Melbourne newspapers. And so there is that level of anxiety that barristers are dealing with their clients, and that really the clients don't want the matter necessarily to be reported on. So there's that sort of extra level to it as well. In terms of the trial itself, I think one of the main bugbears of barristers is if a reporter doesn't follow the trial, as the judge was just saying. It's fine to turn up for one day, but there's nothing that really compares to a journalist who is in court every day, has a real knowledge of the fundamental issues in the trial, and you can see the difference in their reporting when they understand that. So, for example, you might have a prosecution witness who gives evidence perhaps for a day, and that's not necessarily unusual, perhaps in a complex trial or a murder trial in the Supreme Court, that they are giving their evidence in chief to the prosecutor in a nice, friendly way with these sort of questions and answers back and forward, and the evidence sounds pretty strong. And you might walk out of court at 4:15 on that day thinking, gee, you know, the accuser's in a lot of trouble, that witness was excellent. And the reporter might leave and just report that for the day and not come back for the next day when the defence barrister, who is a skilled cross-examiner, rips this witness apart and chips away, which is, of course, their job to really test that evidence and destroy the credibility or reliability of the witness if they can. And all of a sudden, all that brilliant evidence that they gave for the prosecution the day before is really changed and really affected. But the reporter is not there to then, in my view, fairly and accurately say, well, this is what happened to this witness on this day, and that evidence is not as strong as it was for these reasons. You know, the cross-examiner was able to say that, you know, the witness was drunk or drug affected at the time, or has said something different in the past, or whatever the reason might be. So I think that's really one of the issues that barristers have with court reporting. And of course, as Justice Niall said, reporting of things that happen in the absence of the jury, and which is, you know, really the number one rule to make sure that doesn't happen, because I've seen it derail trials before, and juries get discharged, which is obviously a cost to the community, but also the emotional toll that takes on either a complainant victim or the accused on the other side of things.
I think one of the things about reporting probably would be to identify what are the key times in the trial. Particularly at trial, not all witnesses are interesting. A lot of them need to be formally proved matters which are not necessarily that controversial, but it's for the prosecution to prove every aspect of the charge and every element. So if you know that you're going to report a trial, it would be helpful to see the openings. So the judge will initially say something about the trial. Prosecution will open the case to the jury and will explain how the prosecutor, so if it was Sally will tell the jury how she is going to prove the main ingredients of the trial and what the critical issues the jury will really need to be focused on. So a particular crime might have 5 elements. You know, the Crown might need to prove 5 different things, but the defence really knows that 3 of them are obvious and will be easily proved, and the focus of the trial will be on the 2. So knowing what the key elements of the trial will be will really help you work out, and I think avoid making some of the mistakes of going too early or getting up a side stream. And secondly, you'll also know which are going to be the key witnesses. So it'll be, you know, the victim might be a key interest in an assault charge. A couple of other witnesses might be critical, or you might know that the defence is going to run something about the investigation to show that the investigation wasn't thorough and that the police had excluded a possible culprit early. So you'll know that a couple of the police officers, the informant, might be a critical witness. And then obviously the closing addresses give you a summary in which you can report. I don't know, maybe Tammy, you might identify how you'd approach reporting a trial.
Yeah, I agree with you in saying that the best thing you do is go there for the openings, but also even be there for those discussions that happen when the jury's not in the room, making sure that you have it well and truly in your head that you can't report what's being said in court. But often those discussions will give you like an idea of how the trial's going to run. So which witnesses are going to be up on what day and how long they'll take. So then you can do as the judge just suggested is know when those key witnesses are going to be on. Closings are also great too because you get the most thorough summary of both sides of the cases. I would say there is nothing more terrifying than going to court in the morning when you're reporting on a trial and you're waiting for that first 5 minutes of when someone could get up, or a lawyer's going to get up and say that that this report in, you know, the Shepparton News has got something completely wrong, or, you know, you've reported on something that threatens the trial. That those minutes of when you're waiting for the jury to come in and you're sitting at the back of the court with your notepad and you're watching the lawyers are about to get up and rip through your story, it is the absolute worst. And I don't think no matter how many trials that you cover or court cases that you cover, you never get rid of that anxiety of that waiting for that kind of hammer to come down.
And I can say, Tammy, that as a barrister in trials, the first thing you do in the morning is usually scan through your news feeds, see if the trial's been reported. If so, what has been said, and if there's something in there that was not said in front of the jury or is said to be wrong, it is a matter that we would certainly raise with the judge. So
that's the worst.
We usually glare at you before that, so you kind of get a bit of a clue.
yeah, it's the worst. So, but for trials, I think those points of covering the openings, choosing which witnesses that you think might be interesting, and then covering the closings and what happens afterwards are key. If you're at a local news organisation, depending on what your round is, so when I was doing courts for Shepparton News and the Border Mail, I'd often have more latitude to cover a trial, sometimes for the whole thing, which these days at a metro newspaper is almost unheard of, because you're covering things in a smaller community where it's of particular greater importance. Like there's no other more important case than that one that's running about a murder trial from your community. So that may be a great opportunity for all of you watching on from home or wherever you are, that hopefully maybe you'll get an opportunity to cover most of a trial, which is really unusual these days. Yeah.
One of the things about a murder trial is there are some aspects of it they tend not to be that long. Murder trials are not always hugely long, often contested on one or two issues. So it may be that the question that the accused definitely caused the death of the victim, but it might be a difference between murder and manslaughter. That is, whether they intended to kill or cause really serious injury, or it was something less than that, a different, lesser intention. And that's the debate that the trial will be having, and it's relatively easy to follow. Sexual offences, which are unfortunately very common in our courts, have their own difficulties, and we'll come to those maybe a bit later. But I think Tammy's right to say that it's that evolving nature of the trial. If you can understand how the issues are going to play out, it's going to be a lot easier identifying what's important. So those two critical areas, one is there are some no-go areas which just really can't be put before the jury, and they've been excluded, and therefore to see them in the newspaper, particularly a local newspaper, the following morning, that the jury may well read, really threatens the trial. And they might be, as I said, a prior conviction, an admission. So, for example, you might have an admission by an accused to something to police which is held to be inadmissible on the basis that it wasn't properly obtained, the person wasn't cautioned properly, or for some reason it's determined that the admission won't be before the jury. To then read in the morning paper that the accused admitted doing it would be pretty catastrophic for the trial. And sometimes quite difficult issues arise when there's a co-accused. So a co-accused might have pleaded guilty or might be waiting trial, and it may be that the jury are not told all of the circumstances about the co-accused, or it may be that they're there. So all of those things are difficult.
Judge, I have a quick question on that point. The jury aren't supposed to be reading the newspaper or watching the news.
Well, they're entitled, and they're not to read the newspaper about the case or read the news. And the first thing that people might say is, well, we've told the jury, and I'll come to how we sort of deal with these problems. But the question remains, well, there might be a real possibility that a juror might have come across. And if it's something as stark as he's got 4 convictions for murder.
Yeah, or the headlines like, he admitted it.
Yeah, he admitted it. It's going to be hard to see, just not have a real possibility that a juror might have come across that. And had they come across it, it would be very difficult to remedy. But of course, we'll come, I think it's probably a good time now to come perhaps to this issue we're talking about is important of not publishing material that's not before the juror. And the second aspect is what you do publish has to be accurate. So to the extent that you've got a fair reporting, a lot goes with that fair reporting of court reporting. For one, you can't be sued for defamation. There's an absolute privilege about fair reporting of legal proceedings. So that's critical. That's a critical protection. But it all turns on fair reporting, and judges and counsel and their clients can get upset if the reporting is skewed in a way which doesn't actually reflect what had gone on in the court the previous morning. So the reality is that sometimes things go wrong, or sometimes it's inevitable that there'll be prejudicial material around the community which you're just never going to be kept from a jury. So how do we deal with that? And I think it's useful to sort of talk about that as part of the picture. So the fact that the jury gets prejudicial material or might have got prejudicial material doesn't necessarily mean the trial is aborted. And I think there's a number of steps. The first, and I think it's the most important, is the directions that a judge will give to the jury, both at the start of the trial and at the end of the trial. And perhaps, Sally, you might just sort of explain directions and the typical directions that a judge will give a jury.
Yeah, so there is a stage of the trial after the evidence is all before the jury, and there's been opening and closing addresses where there'll be a discussion between counsel and the judge about the relevant directions that need to be given predominantly under the Jury Directions Act. And they're really the instructions, the legal instructions to the jury. So as you may know, a jury is the judge of the facts or judge of the facts in a trial. But the judge is in charge of the law and will direct the jury as to the law. So there might be, for example, identification evidence in a trial. That is, there's been some sort of photo board that a witness has looked at. There are standard directions that a judge needs to give the jury as to how to deal with that particular piece of evidence, what to do and what not to do, what's not permitted, what inferences can be drawn from particular pieces of evidence. So they are matters that are very carefully thought about by counsel and instructions obtained from their client if they are defending the matter. But they are directions that are given that must be followed by every single juror, and that is really the last part of the process before the jury retire to then consider their verdict. So sometimes when these directions are given, defence counsel are concerned that just because a judge tells the jury not to take that into account, or that they must not take a particular piece of evidence into account in that way or use it in a particular way, that won't happen. But generally what we have to do is have faith in the system. These directions have been crafted over a number of different cases over the years, and really it's the system that we have, and it's a very important part of the system.
Yeah, and one of the directions which will be given at the start and then given at the end is that the jurors have to decide, the jury has to decide the case on the basis of the evidence that's before them, and they must not make it their own investigations, must not own inquiries, and the judge will tell them at the very start of the trial, don't go looking for the internet, don't read the newspapers about the trial. You will hear the evidence unfold, and it's on the evidence that you must decide the case, and they will be told that again before they
and in fact that it's an offence if you do so.
And it's an offence to do so. It does happen. Just recently, the High Court allowed an appeal where a juror had gone off to do a search of a topic that was tangential but not insignificant to the trial. And when it was about, I think, the age of consent at a particular point in time. And anyway, the judge didn't discharge. The foreman of the jury told the judge in a note that one of the jurors had made this helpful investigation, and the judge didn't discharge the jury. The Court of Appeal said the judge was correct not to discharge the jury, but the High Court said no, it's an absolute prohibition on investigations or research. It's a problem because information is so accessible and so ubiquitous that there is inevitably a temptation on a juror to Google, but they're told very strictly it's an offence to do it, and the legal system accepts that jurors follow the directions that are sternly given by a judge, and the system has to accept that the jurors will abide. They take an oath or an affirmation, and they will abide and subject to the directions of the judge. So that's one way we deal with it. If it can't be dealt with by a direction, sometimes it's so bad that it might be necessary to discharge a jury. Now, that's a very serious thing to do. Particularly if the trial's been going for some time. It's a huge cost, but more importantly, it's a massive burden for the witnesses, and it's a massive burden for the accused to have to start that trial again. And so there has to be a pressing or a serious need for a discharge, but it does happen from time to time, and it has happened as a result of material coming through reporting or some other means to the attention of a juror. So it's a serious issue. The other is the possibility of stay of proceedings. That is, that the criminal charge stops. Now, that might be temporarily, it might be an adjournment. So a trial, you might discharge the jury and go away for a month or 6 months. And there's a general sense that the information will dissipate. We've got to be realistic about that in circumstances that a lot of information on the internet is indelible. But again, a fresh jury would be told not to do these investigations. There is the capacity to permanently stay a proceeding if you can't have a fair trial, but it's extremely rare virtually unheard of to stay a trial as a result of prejudicial material or prejudicial publication. Even for very, very high-profile accused people who everyone in the community will know will have been through and convicted of an earlier offence. And I think, Tammy, that's probably one of the things that's most daunting for a journalist, the possibility that the jury might be discharged.
Definitely, yeah, definitely. As I mentioned, the scariest moment is if your story is getting talked about just before the jury comes in. I think another helpful tip is to actually introduce yourself to the legal team on both sides when it's appropriate. So at the start of a trial, during a break, or when they're not looking too frantic, which they often do because it's pretty full on to run a trial for the legal teams. But I find that going up and introducing yourself to them and saying where you work and what your name is really helpful in that you can both get information about what the running of the trial is like, or even just the committal, or the court case, what witnesses to look out for. If you've got a relatively media-friendly lawyer that won't mind telling you, and sometimes defence lawyers and prosecutors may use that to their advantage to be like, oh, this is that's our witness, this is the witness that we're going to, or this is the witness that we're going to tear down. Make sure that can be really helpful for reporting as well. And also, if you're not sure about something, Peter Gregory, who was a court reporter for ages at The Age, he often tells people that even if he understands the argument himself, he would often just go up to one of the lawyers in a break and say, if I write it like this, would I be getting that argument correct? And that's an opportunity for the journalist to tell the lawyer that they know what they're talking about, or they are a bit more experienced, or can understand what's going on. Or it's an opportunity for the lawyer to say, that's not quite right, this is what I meant. And then you've then struck up a relationship with that lawyer as well, so you can continue to ask for information, essentially. So I think that's a really helpful tip, because you can sit in the back of the court, in the Supreme Court, in the County Court, in the Magistrates Court, all day and never speak to anyone. And court cases can play out in front of you, and it's fairly incredible, and there's a story there. But to become really the best court reporters in the business are the ones that know how to make contacts, and meaning you go and talk to actual people that are involved in those cases, and you strike up relationships and you get information, not necessarily about that court case, but about anything else interesting that's happening around the courts. Steve Butcher was a court reporter for 30 years at The Age. He was the best at it. He knew everyone, from the security guard walking in to the clerks, to the tipster, to the judges, to everyone. You literally could not walk in a court building with him without him being stopped about 50 times. And he really prided himself on developing those contacts. So I think it's, if you're able to, at an appropriate time, go up and talk to the lawyers, and I think that's a really great idea too.
And look, from the lawyer's perspective, I'd say, Tammy, that I would agree that most lawyers would be very happy to be approached by a journalist at an appropriate time when we're not too busy. And it's really good to have that relationship. We're happy to confirm details, perhaps the spelling of a name. I know that when I'm prosecuting in a plea hearing, for example, and I've been reading an opening from a document, I am happy to hand that over at the end, so that might assist the journalist who's trying to, sort of frantically do some sort of shorthand, not being able to record the proceedings, of course. So I think most of us are pretty happy to help to make sure that reporting is accurate. And I can say from my own perspective that relationship has helped me from time to time. So I can recall prosecuting a circuit at Warrnambool a few years ago. And for those of you who don't know, when you prosecute a circuit, you get sent down for sort of 4 weeks to Warrnambool. You might do a trial, you might do a few plea hearings, a few appeals, so where someone's been sentenced in the magistrates court and appeals either their conviction and sentence. Basically anything that comes before that county court judge for the month, you're it. Quite often it's all last moment. You've got one solicitor down there. The police that might be involved in the matter have now moved on to another station and are not around. I was prosecuting an appeal in front of a county court judge. I'd been given some material, but obviously not the entirety of the material. And this fellow was in custody and he was coming before the court. And the material that I had in front of me was that he did not have any prior convictions. He was asking for bail, and as I said, the material that I had suggested he was a clean skin, had no priors. The judge was asking me what the prosecution submission was, and I was saying, well, Your Honour, Mr. Smith has no prior convictions, and I could hear this sort of clearing of the throat behind me, and there is the reporter from the Warnie Standard. And he's going, Miss Flynn. He's got about 6 pages. I've been reporting on him for years. And it turns out that I simply did not have that material. So I was very grateful to that journalist from the Warnie Standard who helped me on that day. And really, it was my job to assist the judge to put the proper information before him so he could make a proper determination of the bail application. So from my perspective, certainly journalists can help barristers as well as vice versa.
I'd add to that, of course, that the Supreme Court has a media team led by Sarah Dolan with Anthea Cannon and Andre Awadala, all journalists. And I think it's important that the fact that our court, the Supreme Court's got a media team, the county court's got one, and the magistrates court's got one. I think it reveals that although it might feel for some journalists that the courts are hostile to reporting, that's not the case. Each judge, each magistrate would take as very important the fact that proceedings are in open court, that people can observe them and they can be reported. That's essential to the system. And it's why making suppression orders are difficult, making closed court orders are difficult, and they cause a lot of difficulty. So it's difficult for judges to obviously talk to the media directly. They really can't. But the media team is a means by which information about cases on the record can be provided to journalists. So they might work out how you could get access to the transcript, work out how you can access to the court file, which will be the documents that have been filed by the parties. And that connection with the media team is pretty much essential to ensuring a really important resource that the court provides in aid of open justice, in aid of accurate reporting, which is pretty essential. I mean, I know Tammy talks about the anxiety a journalist might have when a judge is pretty grumpy because of the report. Judges are very concerned with the fairness of the trial, and that probably is an immediate preoccupation, as you'd understand. The parties are there and it's really important. But every judge, I'm sure, is confident and of the importance of open justice. And so every judge, I'm sure, wants reporting and accurate reporting. So I think there's no hostility, but it's a difficult task coming into court. Arguments can appear complex. Sometimes the role of defence is to make things look a lot harder, a lot more confusing than actually they are. So, it's not the role of defence to make it all look simple. Sometimes it is, but often it's not. So that's a really important resource that you should all access if you're reporting in the Supreme Court. There's corresponding provisions, corresponding supports in the other courts. There's a couple of other areas which I think are worth mentioning. We've talked about some sort of no-go zones. There are statutory prohibitions on reporting of certain things, and you really need to acquaint yourself. It's not open, it's an offence to report the names of victims of sexual offending. And also children's court is pretty much verboten reporting of children's court in terms of identifying anything that would or identify children. So there's those two important statutory prohibitions or protections of the process. There's an ability in the courts to make a suppression order, that is a non-publication order of anything concerning the case or everything concerning the case, and also the capacity to make a closed court order. As you all know, court doors are open. People can come in and hear court case and can come and go. It's open. And a court will only be closed, or a suppression order will only be made where there really is a compelling or an important reason, where there's a risk, for example, to the administration of justice, safety of a particular person. But they need the party seeking the order, or the court, if it's satisfied an order should be made, needs to have material on that. And there's a process under the Open Courts Act, which is quite not burdensome, it's not the right word, but it's a process that has to be adopted before a suppression order or a closed court order is made. But once there's a suppression order made, it's really critical, essential, that it's complied with, and non-compliance can result in a contempt of court. And we've had charges of contempt of court laid against journalists and news outlets over the years.
Suppression orders are a giant bugbear of mine.
We've actually got some questions about suppression orders starting to come in.
Why don't we hear some of those?
Yeah, so Emma Field from the ABC has asked about under what circumstances a courtroom might be closed, and then she's also said that she was in a courtroom once where after the hearing had finished and they had cut the Zoom link, a suppression order was put on the whole case. Under what circumstances are magistrates allowed to put a suppression order on a hearing after it's happened?
Well, the Open Courts Act, which is some legislation in Victoria, empowers courts to make a suppression order. And a suppression order is essentially an order prohibiting or restricting the disclosure by publication or otherwise of a report of the whole or any part of the proceeding or any information derived from a proceeding. So you can make a suppression order after the hearing is completed. You can make it at the start of the hearing or during the hearing. The Act sets the grounds for making a suppression order, and they include that it's necessary to prevent a real and substantial risk to the prejudice to the proper administration of justice. So you might need a suppression order, for example, if an accused is facing successive trials. They conduct one trial and you there's an order suppressing the verdict or even perhaps the existence of the trial until the second trial has been heard and determined, so that the jury in the second trial doesn't know the outcome of the first trial. Another one is, there are a number of grounds. Another ground is necessary to prevent prejudice to the interests of the Commonwealth or state or territory in relation to national or international security. Although it's under different legislation in Canberra, we've got the trial. We don't have the trial, but there is the trial of the solicitor Kaleri, which involves suppression of some material in the national, for national security reasons. Another ground is necessary to protect the safety of any person. You might get a suppression order in relation to the existence of an informer or the identity of an informer. That's a well-established circumstance in which a court will protect the identity of an informer, serving two interests. One is the obtaining of relevant information, and also the protection of people who come forward to assist authorities in the prosecution of serious offending. Another ground is necessary to avoid causing undue distress or embarrassment to a complainant in any criminal proceeding involving a sexual offence or a family violence offence. So there are a range of circumstances, and in relation to closed court, which the question covered, there's another power in relation under the Act to close courts. And again, it's on similar grounds, necessary to protect public interest. So the court has to balance the extreme importance of open justice and having things in open court against these particular, often narrower, but nevertheless very important interests of protecting the administration of justice itself, protecting the safety of witnesses, for example, an informer, for example, or other things. What's your experience, Sally, of suppression orders?
I would have said, in my view, they're much harder to obtain now. So either a closed court order or a suppression order. I think there's been a real change in the way that courts have approached them. And if you look back around the sort of gangland war times, I think that there were these sort of really suppression orders which went for life or 50 years or 35 years or and seem to be easier to obtain. But I would say, in my experience now, they're much more rare. Judges really put either party who is applying for the order through their paces as against the criteria that Justice Niall just set out from the Open Courts Act. It's not a fait accompli. It is a difficult process. You need to have substantial material to either close a court or obtain a suppression order, I would have thought.
And for both orders, other than on the interim or short-term basis, the media organisations are notified and can be heard on those applications, and that happens as well. Speaking at a conference to one journalist, she said that wasn't so much she didn't have a difficulty with suppression orders, but it's really sometimes they're a bit unsure or unclear. It is important for the courts when they're making a suppression order to make it clear. It's an order that people have to comply with, and that's not always easy to draft a suppression order that's no wider than is necessary, but is clear to those who have to comply. What's your experience, Tammy?
I have varied experiences. Like I've been in court when before magistrates and judges who have where I haven't had to seek legal advice or get up myself to try and argue because the magistrate or judge has put the counsel that has made the application for an order through their paces and sometimes has come down in favour of not putting in place a suppression order. I've also been in court where there's been no notice given to us. You're supposed to give, I think, 3 days or something like that. And an order is made and there's no discussion and there's no opportunity that's been afforded to media to make an argument. So it's been varied. The thing that I find frustrating is when we aren't given an opportunity, because I think we can all, most of us would say that some orders are perfectly understandable and necessary in order to protect someone's life or to protect an upcoming trial or those types of things. It gets harder when there's orders that are made for really broad reasons that aren't explained to us. So someone's defence lawyer will make an argument that this person's safety is at risk, and we're not told exactly what that risk is, and it's just kind of said, and we don't know how, we question whether it's genuine. It could be genuine. It most likely would be if they're making that argument, but just being asked if we have anything to say about it can be helpful. So I would say, although it is so bloody scary getting up in court when you're not expecting it and they're asking you, oh, is there anything you want to say? And you're like, oh shit, like what do I say? What do I say? You do want to, as much as possible, deal with it then and there, because you don't want to chew up more of the court's time. But if there's something, if you can have a look at the Open Court Act, like have a read of it and get your head around it and see if there's something that you could, a line or two that you could come up with to kind of make your case in a way, because I know that a lot of you probably wouldn't have access to legal representation. We're really lucky in the city. We can ring up our in-house lawyers and get them to come down to court in half an hour. Whether when I was working in the country, we didn't have lawyers. We didn't have lawyers available to us. So if you're willing to give it a go and get up, what's the worst that can happen? You just make an idiot of yourself. Like it's
One option, Tammy, might be to ask if the hearing of the suppression order can be delayed until after lunch, give you a chance to ring your editor or ring a lawyer.
Yeah, it's a great idea.
Babble something about the Open Courts Act.
and the process can be an interim order, so that just holds the status quo until, obviously over a trial that's running over multiple days, it's a bit easier to do that because you're coming back anyway the next day or whatever, and delaying of a day or 2 days may not mean the story never sees the light of day. It is obviously more difficult, and there is pressure to keep the case moving. But these points are not minor points; they're really essential. And the Act makes it clear that there are criteria that have to be satisfied before a suppression order can be made, or a closed court order can be made. And I think Sally's right. There is an awareness of the importance of that by practitioners, so that they're not asked for, and that people know that there is a hurdle, significant statutory hurdle to get over before the court will make a suppression order. They're not designed to protect reputation of people who are caught up in the criminal justice system. That's just an inevitability of open justice.
Yeah, even though I'm sure I've definitely been in court where that argument's been made to try and get a suppression order to protect someone's reputation, which didn't fly. So
I've got some more questions from our people who are watching at home. Alison McAdam has asked about the panel's opinions and thoughts on reporting non-conviction cases. So where where the court's decided a conviction isn't necessary, should media outlets be reporting on those matters? And I'll open it up. Tammy, your thoughts?
I would say you're not going to know that it's a non-conviction until the end, and so you're probably reporting on it beforehand, and then you will report on the not guilty verdict, or if the stay, or whatever the outcome is. Then yeah, you should report on it, because it's only fair. In terms of coming into a case having not reported it before and someone's not guilty, it just depends. If it's a good story, then it could be about that person proclaiming their innocence after being found not guilty, or it just depends on if it's a good story or not, really, and what you can get out of it.
Okay, to name somebody who where the court hasn't recorded a conviction against their name?
This is cases where people have been found guilty. But
I believe so. Yeah, it may well be that type of.
Okay.
Yeah, like a magistrate's matter, and it's gone through.
Well, again, I think it all turns on accurate and fair reporting. Often, someone might be found guilty of an offence, and sometimes they're not trivial. But the magistrate, for a variety of reasons, won't enter a conviction on the record. But an accurate reporting, which would include why there was no conviction entered, might be appropriate.
So I know some media outlets have blanket rules on this type of thing. They might say, well, we won't name somebody. But it's very hard, Tammy, in a news environment to have blanket rules, because news is all what it depends. If the person's the mayor of your town.
Then there's public interest.
Yeah, that's right. Yeah.
Or if it's someone that robbed a corner shop and they're not of any public interest, then you kind of wonder why you would report on that.
There's a variety of things about reporting of sentences that might be worth noting. I mean, one of the things is that under the Sentencing Act, the judge is required to impose a minimum term, so that they'll impose a maximum term of imprisonment. Not in every case, but most cases they're required to set a minimum term, and that minimum term is the time at which the person's eligible for parole. Doesn't mean that they'll be released, but the decision to release them on parole is a decision of the parole board. So, for example, you might have a pretty nasty assault, and a judge will impose 6 years term of imprisonment with a non-parole period of 4 years. That means the person has to serve minimum of 4 years. At 4 years, they're eligible for parole, but they might not get parole. And it's the law as a sentencing principle that when a judge imposes a sentence, they've got to assume that every day of the sentence will be served. That is, the Act requires us to ignore the possibility of parole being granted. So if a sentence is imposed of 6 with a 4, it's not accurate, I don't think, or not a full picture to say that the person will be released in 4 years, or the person will have only 4 years to serve. It is accurate. It is accurate that they might be eligible for parole. But I think that the minimum term is not the sentence.
That's right.
And parole has become harder to get. And you certainly don't, by any means, get parole at the earliest possible date. So I think it is right that they'll be eligible to be considered for parole, but they certainly won't. And, obviously there's reporting, might be on the streets in as little as 3 years or as little as 4 years.
I think the other thing to remember, just really flowing on from that, is that there is relevant matters in the Sentencing Act which a court must take into account when sentencing an offender. And one of those is that if an offender has pleaded guilty, and depending on what stage of the proceedings the offender has pleaded guilty, they are entitled to a sentencing discount as a matter of law under the Sentencing Act. I was reading an article this week, it might have been the Age, Tammy, I'm not entirely sure, about quite a nasty rape. And the article said something to the effect of the defence barrister tried to argue that Mr Smith should get a discount because he pleaded guilty. As in that's some sort of outrageous argument to make in a case which is so serious, and the gravity of the offending is so serious. And so I think it's important to remember when reporting on that particular aspect, the defence barrister is doing their job as a matter of law, bringing that matter to the sentencing court's attention. So there can be some sort of, sensationalising of those arguments when really that is the role of the barrister in that particular circumstance. Now, if they were to say something like, well, because the offender's pleaded guilty to these very serious rape, he deserves a non-conviction good behaviour bond, well, yes, report that that's a ridiculous argument to make. But there are certain principles in the Sentencing Act which a barrister needs to put before the court.
Fair enough.
Yeah, it mightn't have been the age, sorry, I can't remember.
I think probably sentencing is an area where there's obviously a lot of reporting, and I assume that in many ways they're relatively easy to report. The judge reads out a summary of the offending, sets a term of imprisonment that's serious enough, and it's all done on the one day, and it's easy to report, and people understand what's happening. I think it is important that reporting accurately and fairly reflect the sentencing process, which is often very complex. It's often commented by judges that it's the most difficult things they do. There's no single sentence for a particular crime. There's a lot of variations. There was a very interesting study done in Tasmania of jurors who sat through the trial, and the person was convicted, and they would then come back at the sentencing process, and they were asked to arrive at the sentence that they would impose on the basis having heard the trial and heard the plea. And the statistics were that they were markedly less as a cohort than the sentence that the judge actually imposed. And it does suggest that with the full information, people understand or are quite comfortable with the sentences that are imposed in many cases. But if all of they're told is that there was a nasty assault and a terrible injury, and the person only got 40% of the maximum or 20% of the maximum, whatever it is, it's difficult for them to understand, A, what that means and why the sentence was arrived at. And that's why our job is to explain to the person who's being sentenced and the community how we arrive at the sentence that we do. And then there's an opportunity to appeal to the Court of Appeal in the event there's any error in that process. But I think it is a complex process, and it's very difficult.
Tammy, there's been a bit of discussion about balanced reporting. You can sit through perhaps a matter for a whole day, and at the end you might have 500, 600 words, maybe max, maybe less, to distill the whole case and to be balanced. How difficult is it to do all that?
It's really hard. Yeah, it's really hard because you're obviously looking for the most interesting bit of the day to lead your story, and that could fall on either side of either defence or prosecution, depending on what's happened. What I like to make sure that I do, and I know that Adam, who is our dedicated court reporter, he does this. He will put, like, in the first couple of lines or the second or third part, the other side's argument. It could be Mr. Blah Blah has pleaded not guilty, and he said it was actually this other person, or he was never there. So it distills the defence argument, and it's still right up at the top of the story, even though that you've most of the story may be favourable for the prosecution because that was the most interesting thing that happened that day. But it's really difficult. And you try your best, and you try and make sure that you've got a bit of both throughout the story. So you're covering it in as balanced way as possible.
It's more interesting to read like that than to have one slab of prosecution at the top and a slab of defence at the bottom or something, isn't it, as well? I think you get that bit of conflict in a story. I'll move on with some more questions because we're getting a few start to come in. Jessie Gartland asks, at what point is it okay to name a defendant? I ask this in reference to all levels of court.
Well, you can name someone charged with a crime or straight away, unless there's a suppression order in place. I've named people before they've been charged, which is often a bit hairy, because you may think that this person did it, but it doesn't mean that they did do it, and the police may actually charge someone else. So sometimes I've particularly with when you're writing about cold cases that haven't or charge hasn't been made, I've stepped back and gone, okay, what if I name this person and describe them as the prime suspect? What if they're not? Like, what if they're not? And I've said that someone's done this terrible thing that they didn't do. So I will sometimes not do that as well because of the fear of doing that to someone. But when someone's charged, you know the name, you've confirmed the name, you're 150% sure that that's the person charged with assault, for example, then you can name them. So you can say Peter Smith, age, has been charged with assault and will be facing the Shepparton Magistrates Court this morning. Like, that's okay. You can do that, but you've got to also make clear that it's a charge and it's an allegation and it's an accusation, so it's obviously not proven. And you can continue to name them through that court process unless a suppression order has been made. And also keeping in mind too, when a committal hearing is completed and they're going up for trial, and the trial might be, say, a year away, you've got to start thinking about what kind of reporting you can actually do in between that committal ending and the trial starting. If there's pre-trial arguments, do you want to report on it if the trial is within like a month? Potentially not, because that would be prejudicial to the trial, or it would affect them finding a jury that wouldn't have read that particular story. So often we will not report on those pre-trial arguments, even if there's no suppression order that's preventing us from doing so. Yeah, but back to your question, you can name them as if you go through the steps that I just spoke about.
Greg, can I say something about naming counsel that's involved in matters? And one of the things that this audience might not know is that in Victoria we have something that's called the cab rank principle for barristers. And that is, if barristers are approached with a particular matter that is within their area of expertise, and they're willing to do it for the fee and they are available, just like a cab rank has the taxi at the front and the person gets into that cab and then the second one, that is exactly the way that our rules of the bar work. So we can't pick and choose our clients. Theoretically, that's the way in which it works. So we have defence counsel in Victoria who have to take on high-profile, notorious, really difficult cases. And in recent times with social media, in particular in the notorious cases, There's been many instances of journalists reporting a story and accurately reporting it that, and I'll use my name as an example, but it's not about me. Miss Flynn appeared on behalf of the accused. And at the end of the day, there is Facebook or Twitter, there is calls to the clerks, there are letters and notes sent to my chambers. How can you act for this particular person? Really bad sort of social media trolling. And so I would just like to raise that as an issue. And it might be, if you are sitting in court, Tammy, that you might be able to say to that particular defence counsel, if it's a notorious high-profile type case, are you okay if I report your name? And it might be that the defence barrister is sort of, media hungry and quite likes to read their name in the newspaper or be shown on camera, and that's fine. But if it's not necessary for the story, and I would say it's not, I don't understand why it can't be reported. Defence counsel said, and whatever the report is. So, I'd just like to raise that as an issue about whether the actual reporting of that person is necessary for the story, given that there can be significant ramifications for that person, for that barrister who is doing their job, abiding by the rules of our bar. That is, that everybody deserves the right to be represented by a competent barrister.
It's a really interesting point. I've never contemplated the kind of trolling and those types of messages that you and others would have received.
And I think it's, the last couple of years, it didn't used to happen, but we hear some really horrific stories. I'm Vice Chair of the Criminal Bar Association. I'm the former Chair of the Health and Wellbeing Committee. So you hear these stories, and it's not only barristers' mums, found on Facebook, and your daughter's an absolute disgrace. It's just terrible things. So just something to keep in mind. Your average sort of magistrates court drink driving matter, you won't necessarily find that, but it's some of those more high-profile matters that really excite public interest and public sympathy, I think, can make a difference.
Yeah.
I guess from a media perspective, we would feel that the court's an open forum. Anybody can walk in off the street and watch it and see that you might be representing that person. It's an interesting request. I guess
how I'd handle it. So I'd have absolute sympathy for that, for the argument. But then I wouldn't want to set this kind of precedent of not naming people as well. But I'm not sure how I'd handle that.
And the question around how much responsibility do we take for what trolls do off stories we write?
Yeah. It's really interesting.
There was a question here about around the reporting of sexual offences. Obviously, we can't report the name of the victim, but under what circumstances can we report the name of the alleged offender? There's obviously circumstances here where identifying an offender might identify a victim, and as a journalist, Tammy, you have to make a call what information is most important.
Yeah, and that's a case-to-case call. So say if the person charged is their former partner or partner, then you can't name them because it identifies the victim, and you really don't want to identify a complainant, particularly in a sex crime or an alleged sex crime. The circumstances where you can is when the relationship with the complainant, by naming them, it doesn't obviously identify the complainant or doesn't even tend to identify the complainant. The problem is the language around it is tend to identify, which is really broad. It all is dependent on that relationship with the complainant. And again, that's kind of like not a hard and fast rule there. It would just depend on the case itself.
This is perhaps a slightly technical one, Your Honour. If an offender committed a crime decades ago but was under 18 at the time, are they still not to be named? And at what point does this not apply?
Tammy?
Well, they wouldn't be dealt with in the children's court if they're now 54, for example. I don't know.
I don't think you can name like a crime that someone was convicted of when they were a child, no matter how old they are now.
But if they're not convicted, if they're being dealt with now, if there's been a historical complaint, for example, I think is what the question might be.
Okay, cool. I didn't understand the question. Apologies. Great question.
We take that on notice.
Yeah, I'm not sure. I'd be careful.
So here's a question that could really be answered by all from Min Dang. But it's posed to you in the first instance, Tammy. Have there been times where reporting has really affected you, and how did you manage it? I imagine vicarious trauma applies to all of you sitting on the panel tonight.
Because you're witnessing the rawest emotions and the worst day of people's lives, and it can be really horrific. And I think that's one thing I think about when people say that judges are out of touch. How can a judge be out of touch when they're presiding over these like moments of horror and the best and worst, most and often the worst of society? So yeah, there's been lots of cases that have affected me, and the way that I've dealt with it has got better over time as I've become more experienced and identifying kind of the warning signs that I might not be coping. And the best thing that you can do is talk to someone, and that might be another colleague, but also like if you've got counselling that you can access through work or outside of work, then I think that's a really good way to sort of dump out of your brain what you've just witnessed in court. Us as journos have a reputation for just and something that lawyers I think do as well, going out and just getting drunk and dealing with it that way, and that's cannot be particularly helpful if you're doing it over a long period of time and the cases build up. So I think trying to have a way of talking about it, and if you get to a point where you're feeling burnt out, then you've just got to give yourself a break. I think that sometimes court reporting, you may not be able to do it for a really long time because it's just not healthy. It's not healthy. You might need a bit of light and shade. So that's kind of why I have changed grounds here and there, just to give myself a breath of fresh air and a break, and kind of be outside of that space as well.
Yeah, I think if you think sort of courts at ivory tower, I think the two places you go are public hospitals and the courts. So I think that's where you see people, the whole range of people in most vulnerable positions and terrible circumstances. The area of vicarious trauma has obviously become more understood or better understood. The High Court handed down a decision last week on appeal from our court concerning vicarious liability for a solicitor from the OPP, the Office of Public Prosecutions, who had a claim effectively for a post-traumatic stress disorder vicarious trauma resulting from working in the child sex unit of the OPP. Won at trial in this court, went to Court of Appeal, and the defendant won, and then it was reversed in the High Court. And there's quite a bit recently in that judgment about this whole area of work which has obviously got risks, psychological risks if it's repetitive and not supported. And obviously we see in the courts a lot of pretty horrible, particularly, but not exclusively sex offending, but child sex offending is obviously one that's extremely traumatic. Culpable driving involving young people, also very traumatic for people.
How do you both deal with it? And what's your tricks?
I think a similar strategy to what you've said, Tammy, and that is either professional help or talking to colleagues. So I make it a point not to talk to my husband or family about the cases that I do, but talk to my barrister colleagues and friends who understand that kind of work, and have that debrief before I go home, so that when I go home, I'm just myself without, sort of carrying on that burden. But also professional help. I think there's been a real change in recent times that there is no stigma attached to seeking professional help if need be. And hopefully the days of drinking every night are being replaced with exercise and sleep and mindfulness and all those type of things. But, yeah, I'm not entirely sure whether that's worked or not yet.
I mean, I sit in the Court of Appeal now, and I wasn't a trial judge, so we are a bit removed. We don't have witnesses in our court, so you don't see quite the trauma of the trial unfold. I I suppose as lawyers and I suppose as journalists, you do get some measure of objectivity as you work through your career. You probably think it's more protective than it is, but it does provide some measure of distance from the fray, because you just get more experienced in dealing with it as the volume is there.
I think doing nice things that aren't related to work outside of work after days like that is really helpful too. So going for a walk, or also speaking to other people outside of the journo bubble is nice too, so you can remember that not everyone's like terrible and cynical and yeah. But whatever works for you. But it's a good question too.
There's a question here about evidence and the need not to report evidence that might be prejudicial. And for instance, somebody who has been prosecuted previously for other crimes. What if they're well known for those other crimes? Is reported? Is it okay to mention them under those circumstances?
No, you can't. So we can talk about someone like Peter Dupas, for example, a serial killer who appeared before a court semi-recently, and even though he'd been convicted of several murders beforehand, you could not say that. And sometimes someone is so notorious that potentially there's suppression orders that are put on place for the whole of that new proceeding until a result, maybe they're convicted, and then you can talk about everything. But it doesn't, just because someone is really well known for the previous things they've done doesn't change that pretty golden rule of you can't report the previous crimes. You can report the previous crimes once a decision's been made. So if they're convicted, or if they're potentially, you could contemplate, but you may need to have a bit of a chat to your editor or a senior reporter, or better yet, a lawyer, whether you can talk about the previous crimes if they're not convicted. It's sort of the point where the juries have done their job, discharged their duty, the case is over. Often that's when we'll roll out I was actually convicted of the same crime, and, jury was never told this because it's prejudicial, and, that's when those stories can come out.
Sometimes there can, though, be forensic decisions of defence counsel if somebody is so notorious. So, for example, I think I'm right in saying that Adrian Bailey, after he pleaded guilty to the murder and rape of Jill Maher, was then tried for a further series of rapes. And my understanding is that defence counsel in that knew that pretty much every potential juror would know of that. And so the jury were told in very strong terms by the trial judge in each of those, I think, 3 series of trials that, to put that completely out of their mind, that wasn't something they could use. And in fact, he was acquitted of at least one of those trials, which shows, it gives me as a barrister a great deal of faith in our justice system when a jury, having known of the Jill Maher conviction, was still able to acquit. So I think it's, if somebody is so notorious, sometimes there is that forensic decision. You don't want to treat a jury like they're completely stupid and that, and pretend that the elephant in the room is obviously that they've recently been found guilty of a very high-profile serious offence.
Yes, so sometimes, but that if the jury are told that, then you can report it.
Yeah.
But it is a rare case where the jury are told. Sometimes you get a case where a witness might be asked, now, did you know the accused? And says, oh, yeah, we shared a cell together. And obviously, you'd get a discharge of a jury on that pretty quickly.
Is that because that says that they're in prison?
Yeah. So, but if the crime is an assault in prison, obviously the jury are going to know that the person is convicted of something and spending time in jail. But they might not know, and they might not be told, and probably unlikely to be told, what the crime was that took them into jail, for example. So you might be able to say, well, the fight occurred in jail from 2 prisoners, but you couldn't say, well, one of them was in jail for 5 criminal assaults or something if that wasn't before the jury. So it just comes back to that sort of golden rule of if the jury don't know it, you can't tell them.
And it could be even so prejudicial. It is so prejudicial to say someone was, say someone gets charged with murder, it's at a magistrate's court stage of filing hearing, the very start of everything. I would say that it would be so prejudicial to that person's case if you said even at that point that Joe Bloggs was convicted of this another murder or a crime of any kind just before they're about to appear in their first court hearing.
And one of the things, going back to one of the earlier questions about naming people pre-charge, one of the concerns that a journalist will have is not so much the interference with the criminal process, but defamation becomes a live issue there because you don't have any privilege as a result of reporting on court proceedings. And if you say, well, often, these defamation cases are around about the subtleties of police suspect that John Smith is the murderer. Really, it's not a small step to an imputation that the newspaper's saying that John Smith's the murderer. Yeah. And then you might be up on a defamation suit.
A huge consideration that I didn't contemplate before.
That broader issue that we're discussing, I think, highlights what's one of perhaps the most root causes of tension between the court and the media is that the media tends to be very impatient, deadline-driven, where the court is a much more patient place and is willing to wait the time that's required, and sometimes that's not necessarily how the media wants to operate. We want to get it out for tomorrow's paper, tonight's news bulletin, isn't it? It causes some tension sometimes.
So we should call our best witnesses early in the morning, Greg, so you've got time to write the story but get it filed by 4 o'clock. Okay, I'll keep that in mind.
Your Honour, Sally mentioned before that she's always, no matter what side of the court she's in, that she's always very aware if there are journalists in her court. Is that something that you're aware of?
Well, obviously on the last couple of years we haven't really. We would know that there's a stream. I think journalists don't tend to come to our court much.
Yes, we do.
Do you read reporting of cases?
All our judgments are published, so they report when we hand down the result rather than the argument, unless they want to get 2 days argument rather than one. Occasionally we've had some high-profile cases, of course, and we have not only as a result of COVID, but before COVID, we've had live streaming of some cases. And they have had a lot, I had some data and I meant to bring it with me, but they've had a lot of hits from people outside of Melbourne. There was a class action Banksia which sort of went wrong out of, Myrtleford, I can't remember where it was now. But Kyabram, most of the investors were from there, a class action that settled and then someone was overturned. That had a large number of hits from people watching from Kyabram and from the regions, and other cases. The statistics were high, not as high as Djokovic. I'm told that had an incredible number of hits, like in the hundreds of thousands from all over the world. Judicial review in the federal court is not the most exciting thing, even when it involves the number one in the world. So there's those opportunities, and I think it'll be interesting to see the extent to which the courts continue to make available streams for particularly regional cases, regional media outlets, to enable them to report. Because although obviously courts sit regionally, it's not uncommon for people to be tried in Melbourne, even though the offences occurred outside of Melbourne, or witnesses or people have an interest outside, and local media outlets would be keen to report.
Sally, do you find that you view or your approach to the media is different depending on whether you're prosecuting or defending a client?
I wouldn't have thought so. I would have thought that I approach any journalist with, sort of courtesy and professionalism. But as I said, there is that added pressure when you're a defence counsel from your client, and your client is sort of saying to you, stop this from happening, don't, and your client doesn't want to see you sort of having a joke in a corner with a journalist if that particular reporter, is writing for a paper and has been against the client during that time. So, but no, I wouldn't say I'd approach it differently, but you've got to bear in mind that there is that added pressure from the client, and, you are there obviously to assist the court, but to pursue your client's interests, and you're not interested in helping you guys sell newspapers or podcasts or whatever it might be.
Tammy, we've spoken a bit about time pressure, and how does a working journalist on courts keep abreast of all the matters that might be going on and find out where the best things are happening?
The courts, as mentioned before, all have media teams now, and they are really helpful in terms of chasing up dates and where matters are up to. So I'd suggest giving them a call if you haven't spoken to them before, and saying hi. And also practical things like keeping a diary is really helpful, because if you're covering so many court cases, you can forget where they're up to when you scribble down on your notepad that it comes back for a mention on, April whatever. If you put it into a diary and put it into your calendar, then it's good you can keep track of it. In terms of bouncing around from case to case in one day, which is never ideal but always happens, online court has made that a lot easier, but I'd say there's nothing that replaces like being in court in person. So I'd say if you can get down to court. The temptation is easy. Like, there's a temptation to stay at home, like roll out of bed and switch on the computer and cover 5 cases or something that day. There's nothing like being in the courtroom and seeing the emotion and being able to talk to people and creating those relationships and contacts. So, get down to court is definitely the best advice.
That's a great segue. We've compiled a list of all the contacts for all the Victorian court media teams across the various courts, and I wanted to make sure that everybody on the call tonight knew that we'd be emailing that out to everybody in the next 24 hours to make sure that you've got access to all the best contacts. Judge mentioned earlier about Sarah and her team. We're hugely grateful to them for allowing us to use the Supreme Court here and all the help that they've provided in letting us run this seminar tonight. But I think our hour and a half is pretty much up, guys. So, Your Honour, Sally, Tammy, thank you very much. You gave up your time without hesitation when you were asked, and you really got behind the concept of what we were trying to do tonight. We hope that it's been helpful for people. I'd like to thank again Sarah and her team at the Supreme Court for making this possible, and also members of the Rural Press Club of Victoria Committee, particularly Laura Griffin, Min Dang and Bryce Eichhold, our president. And without any more to say, I just encourage everybody to make use of that resource when we send it out, the contacts at the court. Feel free to engage with our club, and hope everybody has a really good night. Thank you very much.